those motions. But in the meantime, we have the next best thing. We have the Deputy Public Defender for Los Angeles County, Philip Dube, with us. And Philip, I'm glad you're with me. You're the perfect guest for this because these are important issues in this case. We talk about, prejudicial value versus probative value, or prejudicial effect, versus probative value. This is one of those situations where I think this is an important piece of evidence. But should this be in front of the jury? We'll start with the idea that Arbery was on probation. Let's discuss that.
Well, I'm assuming he was on probation for a misdemeanor offense, right?
Shoplifting,
what is that?
Yes.
Yeah, that's petty larceny, I don't know what relevance it has. If he were on, let's say, probation for a violent or serious felony or a crime involving a residential burglary, now we're talking. But obviously, this young man is not alive to take the stand and be impeached with that prior conviction or even the prior conduct. I don't think it has enough relevance. I truly don't. The fact that a person is on probation could also backfire because they'll bring the probation officer in or whoever oversees him or supervises him to say that he was a splendid, compliant probationer, never had any problems, did his community service, paid his fine, and has never reoffended again.
Well, I want to dig a little deeper into your answer there. You said, had this been something for a violent felony, for instance, that might be a different story. How? Because, again, the argument would be that it would be very prejudicial for the jury and that the defendants in this case had no knowledge of that. So how does that play into what happened and what these jurors are going to see on that videotape?
No, the law in most jurisdictions does not require that a defendant have knowledge of a victim's propensity for violence. They don't have to know it in order to defend themselves. They are entitled to open the door to that young man's character to see if he has any prior instances of conduct involving violence. Because what it will do is it will substantiate their use of force against him when they claim that they acted in self-defense. So I respectfully disagree. I think if he has crimes of violence in his background, that should be admissible, assuming they're not too remote. If they're from 15 years ago or maybe even 13 years ago and the young man is now reformed and living an otherwise law-abiding life, it might be too remote and be tantamount to irrelevant evidence. But I think that just allowing in this petty theft conviction for larceny, quite frankly, is just a tall order.
All right, now let's talk about this THC. By all accounts, it is a minor amount, and it was in his system when he was dead. They did the blood testing on it. But again, I think ultimately this is speculative as to what effect it might have had on him and what effect it might have had on the overall way things played out that day. I want to get your thoughts on the admissibility of that.
Michael, let's be honest. Marijuana mellows you out. No one's going to say that marijuana makes you violent and psychotic. At most, all it did to this kid was give him the munchies. Okay, let's be honest here. If I were a prosecutor, I might even stipulate to allowing it in because most jurors, let's be honest, have probably partaken. They probably passed a blunt around at a party and they know the effects. And to suggest that that low quantity in his bloodstream made him a violent psychopath would backfire royally. I would gladly welcome it into evidence, frankly.
But shouldn't you look at it this way if you're a defense attorney, the idea that they know that this person was taking drugs, and it was a small amount, no doubt. But before it was a small amount, it might have been a bigger amount. But also, here's the key. It can affect your judgment, right? Certainly it mellows you out, but certainly it can affect your judgment. It can affect the way you view a situation, which I think is going to be important, not only the view of the defendants, but also what's the view of the victim in this case? What did he see? How did he view what they were doing to him, which might have spurred him to act in a certain way?
No, listen, at the end of the day, marijuana does not make you delusional. It does not make you psychotic. It does not make you hallucinate. That is ridiculous. It's a drug that actually kind of calms you down a little bit. It may make you underestimate space and distance, and certainly you shouldn't drive if you've been partaking, but it's certainly not going to make you violent. I'm not aware of any literature or studies on that. So again, I would let it in.
So you don't have a problem with it being let in, but should the judge let it in this case? They cited a long line of cases where they say, naturally you'd have to bring in an expert to testify and say what effect it had on him. If it's so small that no reputable expert could come in and actually say this had X or Y effect on him, there's no way of knowing that it is all speculation. Should it come in at all?
Well, assuming a judge finds that it is relevant and that it could prove some point, I think the judge should let it in. Otherwise, it does deprive the defendants of their right to a jury trial on that issue. A jury should decide that, not a judge. Assuming it's relevant and they have an expert who can say what effect, if any, it could have on somebody, especially somebody who might be mentally ill and unmedicated, and they may be self-medicating with cannabis, why not? Don't supplant your idea of what it really shows for the jury's view of what it could show. Otherwise, you could end up with an appellate issue. It will deprive him of his right to a jury trial on that issue.
Fair enough. That's an interesting take. You bring in, one side brings in their expert, other side brings in theirs. It's up to the jury to decide if that small amount had some sort of effect on Ahmaud Arbery. All right, stand by, Philip. It's time for us to take a quick break now. When we come back, there was